Welcome to Order in the Court. Hi, I'm Queen City News anchor Brian Blakely, along with my man here.
Chief Legal Analyst Khalif Rhodes. What's going on, Brien?
Always good to see you, especially on this Monday as we start taping here for Order in the Court. We got three good topics for you today. First off, we want to start off with a family that is suing a beverage distributor after their young teen, a cheerleader, a young girl, died after drinking too much of these energy drinks that had too much caffeine in there. And they're suing the beverage company because they say they didn't warn them enough about what was going to be in this drink before they consumed it.
Yeah, this distributor is who they're suing, and they're not the last folks to get sued. The company is saying that we anticipate potentially adding manufacturers, marketers, and influencers, but this is the distributor. So we're talking about a company that's out of Texas, Glazer's Beer and Beverage, local distributor of the Celsius Holdings company product that they sell in their locations. And what they're saying is that obviously, like any tort, it's duty, breach, causation, and damages. So that's going to be in every complaint. But then you also have defective product design, failure to warn, right? And negligent marketing. But you may be saying, Brian, well, okay, but they didn't make the product, right? The distributor didn't make this product, but courts have held for a number of years that yes, a distributor of a defective product can be held liable, often under strict liability, meaning that if a party is in the chain of custody, that supply chain of distribution, and that's distributors, wholesalers, retailers, regardless of fault, strict liability will apply to all of them. And it's crazy because this is like a law school type of exam when they're saying, well, how do you get liability to distributor A? They give you this fact pattern and it says a whole bunch of things about how they had nothing to do with the product. They didn't make the product. They didn't test the product. You know, they never stored the product, but yet the distributor can still be sued and is under strict liability. That is a clear law school type of question. And this lawyer is doing good lawyering by adding every party that you can to the potential lawsuit.
Yeah, I know it's what we talk about quite a bit. Excuse me. When you have these type of lawsuits, you're going to go ahead and go after everybody you can. And the distributor here, they're saying that they didn't disclose the risk of consuming these drinks. And it's, I believe there's over 200 milligrams per can in this Alani New that was consumed by this young woman. And not sure how many drinks she actually had. But still going forward, where do you think the distributor company has to, where do they have to do the duty to warn for this?
And see, again, I think that duty to warn, that's going to be more to the manufacturer, more to the actual, maybe even the potential seller. But the distributor, they don't have a duty to warn. It's really going to be just strict liability. Were you in the chain? That's it.
Yes.
Were you in the chain, supply chain of a product that was defective? Were you on the chain of a product that failed to warn? So their chain, their claim, their defense will be tied really to the co-defendants. If the other co-defendants are found to have negligently labeled or have a product that was inherently defective, then by essence of them being in the supply chain order, they can be held strictly liable without have committed any negligent act, specifically failing to label or notify or warn.
And, you know, this poor young girl, she died of after suffering a deadly cardiac event. Doctors and the coroners did say that she was caused by excessive caffeine consumption. And we've seen this type of thing happen before. I remember with a tea drink that was sold in a restaurant. But the suit here, what do you think goes next here is what happens? Because as you go down the line with suing everybody, do some of them drop off? Do some of them get dismissed? Or do some of them just settle?
A little bit of both. It'll be a mixed bag. There will be some folks that attempt to get this dismissed by filing a motion for dismissal under a 12B6 motion saying that you failed to state a claim. And so that will be your normal response as a defendant. You'll file a response and you'll also file a motion to dismiss. Most claims are dismissed in federal court. And so that's where you'll attempt to get the case tossed. However, these facts seem extremely good for this case to move forward on a negligent failure to label or a defective product. The portion that I'm going to have issue with is, did the label tell you that over 200 milligrams of caffeine was in the can? Well, the defense is saying, yes, we have that on the label. Did you have a warning that recommended or told kids that they shouldn't, consume this product? Oh, yes, they had that as well. So then on the other side, you'll have plaintiffs saying, well, you had these labels, you listed these items, but that wasn't enough. It was an inadequate warning, that the warning should have been further that talked about cardiac risks, cardiac risks, I should say, um, and the risk to minor young consumers, not just telling them they can't or should not take this, but explaining what would occur if you take this. That's the type of risk that you had a warning. You had this label, but did the label go far enough? I think if the label didn't go far enough, that's what's going to take you to allow this claim to continue and beat a motion for 12B6 dismissal request.
But you have laws that should be stating right. Where do you have the federal law or the state laws, or when it comes to these type of things for the consumers? When it comes to energy drinks, is there a certain statute out there that says you have to post all this?
This is going to be more under case law. This is going to be case law that requires that you have warning labels that are placed on there. These are sometimes it's going to be the product itself. So US Food and Drug Administration is going to say what the guidelines for the daily consumption of, caffeine on a day. I know it's 400 milligrams because I was looking at it for this story. So if a person is taking 4 or 5 of these drinks, you're well over the daily requirement for what they recommend. But you're asking, is there a labeling requirement? And the answer is typically no, that it would say you have a duty to warn, but the state or the federal government isn't going to give you a specifics on what that warning should be. It's not like the Surgeon General warning on tobacco that's going to say, hey, this, the Surgeon General tells you that this tobacco can kill you or can cause cancer. Those are the types of things that specific warning will give. But for food or for energy type of drinks, it's going to be based on what tort law has established you should warn, and you have a duty to warn, or you have a claim that's brought against you for failing to warn.
Yeah, and it's certainly sad to see the family there at the press conference as they're announcing this lawsuit, to see everyone that is so upset and just to understand they lost their loved one. You certainly feel for them because it's heartbreaking as it is, and it was certainly a story that we'll keep following and see where that one goes, throughout this case as it progresses. Other thing we want to talk about our next segment. The segment is that guy right there. He is now a judge dismissed his $10 billion lawsuit against the Wall Street Journal over the Epstein birthday card from this past summer. We're going to talk about that one a little bit more coming up after the break. You're watching Order in the Court on Queen City News Plus Live. Welcome back to Order in the Court. Khalif and Brien here talking about some top legal issues that are happening as our court is in session. The second one we're going to be talking about today. Khalif, that is a judge dismissed that lawsuit that President Trump had filed $10 billion worth against the Wall Street Journal. It was a lawsuit from last summer where the Wall Street Journal, over a story that a newspaper wrote about a birthday letter. The president, his name was on it, that addressed the disgraced financier Jeffrey Epstein. But the judge dismissed that case today.
Yeah, I said this when he filed the claim that this was going to be a hard when he brought it under defamation. President Trump is familiar with the standard for defamation. Himself being sued under defamation a number of times and bringing claims under defamation a number of times, so he understands what the standard is. And so you got to ask yourself, what is the standard for a case like this for an individual like President Trump? The normal standard is that a person makes a false statement that they knew or should have known that was false. That's the standard. However, if you are a public figure, which President Trump is, the standard requires a little bit more. You got to go a little bit higher. It's not just knew or should have known and that you did make a false statement, but that you had actual malice when attempting to make the statement. The judge in this case said that there was no record that supported that there was actual malice being done with this story, that there was no attempt to hurt or harm President Trump when making this story, and they were actually just reporting on what the story, how the story, where the story led them. So the court's reasoning is pretty standard for these type of responses from a judge, that the complaint didn't sufficiently plead that the defendants acted knowingly or falsely or recklessly disregarded the truth as required under the definition of the law. So that's why this was dismissed.
Yeah, and it was in the alleged letter that was from Trump to Epstein. There was some salacious stuff that was kind of tied to Epstein's lifestyle. U.S. District Judge Darren Gales said that the president failed to act with legal malice. But he did leave the opportunity open here for him to file again. And
Yep.
that's the thing. And President Trump said today that he would refile the lawsuit that was tossed out by the judge today.
President Trump says in social media response that the ruling is not a termination, but a suggested refiling of what he described as a powerful case, adding that he intends to refile by April 27th. So, yes, I mean, the judge didn't close this with prejudice, allowed it to remain open, giving it an opportunity to amend the complaint, or I should say, refile the complaint. That happens a lot. Folks file complaints and you can either amend it before a judge makes a decision. You may have looked at your complaint and recognize, hey, I got a deficiency in here. So you'll amend the complaint and then reserve it on the other parties. Or you go to court, the other side's asking for it to be dismissed, and you get it like this. The judge says, hey, you in your complaint, you don't meet the elements for this crime or for this charge or for uh this law,
Claim, yeah.
this claim. My brain went frozen right for that second. But yeah, for this claim, just like in criminal law, there will be elements for each type of thing you're bringing forward. So if it's a battery, I had to have placed you in imminent fear of bodily harm, or I had to have physically assaulted you and hit you, right? Or for defamation, it's again, did what was the item false? Did you know or should have known that it was false? And did you act with malice? Those are the three elements. The judge said that, hey, you're missing the element of this claim, and because you're missing the element, you need to go ahead and file an amended complaint to fix the deficiencies. And again, that happens more times than you know.
So defamation cases like this, when we see that happen, especially with President Trump, he's known to attack a lot of his people that publish certain things,
Yes.
write certain things, and say things on air. Going forward, do you have to prove in court with a lot of the discovery when it comes to going forward with anything of some of the how do you produce it? Are there emails that are required to show you? Obviously, there's the work of actually how they got this story for the
Yeah.
Wall Street Journal. Tell me about how works with when you're going with your client. Say it would be the Wall Street Journal.
Yeah, so you're talking about the discovery process. Discovery is depositions, interrogatories. Depositions is sitting down, having interviews with key people that we believe would have information. And so I want to talk to anyone that had touched this story. I want to talk to an editor. I want to talk to who wrote it. But also, when you're talking about interrogatories, we're thinking about questions as a team that we want to ask the other side. And so we submit our questions and then they have to submit those back. That portion takes a long time as well. But then there's also what's called a litigation hold or litigation freeze. There's a litigation happening. You know you're being sued. If you have a legal counsel that's working in-house or outside counsel, they will advise you, hey, freeze all emails connected to this story. Don't delete anything. We have a preservation, requirement because now the court is going to at some point require us to turn over some of these documents. So we can't delete any email that's connected to this. So you ask, how do you figure out or prove your case? Because the burden is on President Trump and his team to prove his case. It's not going to be on Wall Street Journal to defend. They have really no burden, no proof to defend. It's going to really be on President Trump to prove that they acted with malice. So what the emails, text messages, answers in interrogatories, answers in depositions, all of that discovery process will help them prove their case. But it's going to be hard, specifically if you can't show that it was a false statement first. But then if you can get over the fact of making it a false statement, pointing to actual malice is going to be extremely hard. You're going to have to show emails, smoking gun type of emails that show, hey, we're running this story with the intent to, disparage the president, or we're running this story with the intent, and we know that it's false. That's the type of standard that it is for a person that is a public figure. It's an extremely high standard.
Yeah. Okay. Well, that's going to probably happen again, as President Trump said he would refile at the end of the month here in April. That also causes a lot of legal things for the president to refile here because he has to prove that, right?
Well, I mean, he has an opportunity to refile, and so his attorneys obviously are scrambling right now to find a way to ensure that when they
They can
add
prove the malice.
right, and so if you had the malice, they would have listed it in the original
Right.
complaint. They know the elements just like I know the elements, and so you would assume that they didn't have it. That's why you file it without it. and that you hope the other side, when asking for a summary disposition motion, doesn't catch it.
Or okay, or they'll just say, okay, we're going to settle or something.
I mean,
Is
yes,
that what
but you don't settle a case like this without thoroughly reviewing the complaint. And when you're looking and checking the boxes to say, hey, do they meet all of the elements? If the answer is no, there's no reason to settle. Now, if the answer was yes, and they had actual malice and they could point to actual malice, and yeah, just like you've seen President Trump have settlements with a number of other institutions, this probably would have been one that could settle. But if you don't have the elements, we're not walking to the table to settle, especially for $10 billion.
sure. All right, we're going to talk about this guy right here coming up on the next segment. That is Albert, the alligator, and its owner wants him back. We're going to tell you that whole story coming up in our next segment. You're watching Order in the Court and Queen City News Plus Live with Khalif and Brien. Welcome back to Order in the Court. You got our third segment of the day here with Khalif and Brien, and we are going to be talking about a New York man who he has abandoned a 2-year court battle to recover this guy, a 12-foot, 750-pound alligator named Albert. And it was after he was seized a few years ago from his Buffalo area home and then moved down to a rehab or a sanctuary type of facility in Gator Country in Texas.
Yep.
But he's been wanting to get his gator back. You see, he raised him as a little baby there. And he says he's a big baby now, but he wants his gator back. But he says it was just too much to try to fight and get him back.
Albert is in better place than he was there. Let me say this. Albert got to the place in Texas blind in both eyes, suffering from spinal and neurological issues, and unable to fully support his full body weight. Sanctuary staff said that it was primarily because he had poor health, because the water hadn't been changed in 7 years.
They said he built a pool in his
In the basement.
And so it was a makeshift little area where there it is, where he could stay. And he lived there for pretty much and never changed the water for 7 years.
But also was feeding him fried chicken and fish sticks. I mean, if you got a 750-pound alligator, you got to give him raw meat at the very minimum. So, and the crazy part is, this guy had a permit to keep the animal. He had a permit to keep Albert, and his permit lapsed. And the folks said that he just didn't get it updated in time. So to me, that's the part that's laughable, is that all he had to go through was the administrative and due process portion of this, and he probably would have saved himself, thousands of dollars in legal fees. I mean, because litigation,
if he would have done that, even after the alligator was seized.
Well, I think before.
After the alligator was seized, then he tried to fight to get it back, and then that's where he said, this is costing too much.
But I think before there is when he could have kept the alligator. He already had it from when it was growing up, right? And then at some point, permit expires in 2021. They took it 2 years ago, which would have been 2024, 2023, depending on the time. So, okay, they take your alligator, but it lapsed for almost 2 years. The agency said he failed to properly renew, even though he claims his attempts went unanswered. Authorities then seized it, but they said failure to renew was only one. They also believe that he put the public at danger while allowing people and children to see the animal up close. But then the third thing was that they put the animal's health at risk by giving him an unhealthy diet. And so I think
fried chicken and fish sticks there.
Fried chicken and fish sticks to a 750-pound alligator. I'm not sure if that's the standard, but my heart does go out to this man. He definitely seems like he was concerned and frustrated that his animal was taken.
It was his beloved pet.
It
we
was.
raised him since he was a baby, and obviously that's not for everybody, but the fight to get him back, when you lose an animal like that, when you do something like that, the fight and the legal fees to get them back, you still have to do all those things like get the permit. And then how he just said, what is he fighting? What are those legal costs? Who's fighting him for the legal costs?
The state of North Carolina, of New York.
New York. They want him to have the animal back.
Yep. They're saying that even if you would have done what you're supposed to do permitting-wise, you don't have the ability to raise him properly, and you're not taking the proper safeguards to ensure that he doesn't hurt someone else in the future by allowing kids or adults to be near him. So that's the fight. The fight is, did he have an authority to keep an animal like this? I think he at some point, I think he did. Does he now have authority? The answer is no. And would they have granted it to him even after some type of lawsuit success? I'm not sure, and that's going to be the issue with something like this, where litigation just continues to go. As he said, like, they were never going to let me get my animal back, and that was
Mhm.
hard to read, hard to
Mhm.
hear. But to his point, I've been taking care of this alligator since he was a newborn, right? And so at least another year, a year and a half of stress and money is what it would have cost him, is what he speculated, and that cost was just too much. And
Too
so
much.
this isn't one that was, terminated based on the facts. This was terminated based on the cost, and most of the time in court, cost does that. When I talk to folks about litigation, I start at the very beginning and I say, hey, litigation is expensive. Yeah, you'll put this money in our retainer, in our trust account, and we'll bill off of it. You may start with 10,000 or 15,000, and at some point there'll be nothing left, and then you'll have to re-up the retainer. You'll have to put more money into the account.
How do you
That
decide? Yeah.
that portion is where it gets hard for people to say, "Well, darn, do I even wanna go for it with litigation?" And these are folks that have means oftentimes, but they're saying, "Do I wanna spend $50,000, $60,000 on a case, or do I just wanna let it go?" And sometimes the answer is, "I'll spend whatever it
The
takes."
man's heart here obviously did not want to let his beloved pet Albert here go. But how do you decide yourself and exactly what that retainer fee is? Is it the case? Is it based on a percentage of what you think it's going to be? Is it the upfront type of research that you're going to have
A
to
little
do?
bit of both, and so I know what I would say, "Here's my hourly rate." We charge $500 an hour, and we know to start a case like this, just to do the complaint, to draft it, to do the background, they take 10 to 15 hours just for us to start, and so we wanna ensure that you have enough to cover that initial start and the initial, what would happen after a fact. Because every time we get on the phone, that's drawing off of that retainer. Anytime I talk to someone about your case, that's drawing off the retainer. And so recognizing that, okay, you're billing every, 15th, every 15-minute, increment, or every 6-minute increment, depending on how the retainer agreement is listed. So recognizing that that initial deposit can disappear quickly. And so I overemphasize that to clients because I don't want them to recognize that, hey, this is more than I pun intended, bit off.
Right.
And this isn't fish sticks or fried chicken either.
Right? Oh, the poor guy there. Both poor guys, as far as the
Yes.
New York man, who is probably
Hey,
his heart was in the right
I
place. But
tip
the
my hat to
alligator,
this guy, man. I mean, he
he
built
fought.
a pool in his house for the alligator. I mean,
Yes.
that's commendable. I mean,
And he's probably thought, when that alligator got too big, how am I going to change the water? Where am I going to put the alligator for a little bit? And
I
then,
don't think he contemplated changing that water. And then, but to his point, let's be clear: alligators live in nasty swamps anyway.
true.
Are they changing out the water in the swamps?
No, they're
They
not.
probably are not.
But are
And
they
so
changing his diet from fish sticks and fried
they're
chicken?
probably not giving him fish sticks and fried chicken. So
Uh,
I'm with them on the water. I am totally against them on the diet. So yeah, this alligator went blind based on that diet. So yeah, I
Poor
mean,
guy had diabetes, and I don't even know if you could test diabetes on an alligator or something. Well, good stuff today. Hope you enjoyed watching Order in the Court with Khalif and Brien. Those are our 3 segments, and appreciate you, and thanks for watching today. Khalif, good stuff today.
always, man, always.
You're watching Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.